Hi, I'm Greg Dell with Dell Disability Lawyers, here with attorney Stephen Jessup, and we're going to discuss a recently resolved case of Stephen's against Lincoln Financial. And Stephen, in this video, we'd like for you to talk about why Lincoln denied the claimant, what you were able to do as a strategy, and then we'll provide some tips for people that may help them to avoid a Lincoln Financial disability denial in the future.
Yeah, so this denial was one that you commonly seen from the transition in short-term to long-term disability. She went out of work, short-term disability was approved, but then in the transition to long-term disability, Lincoln all of a sudden said the information that we used to approve you last week is no longer sufficient to establish that you aren't able to perform the duties of your occupation. So she contacted us several months after the denial, actually. She had been kind of sitting on it, waiting on it before she reached out to any attorneys.
Now, you said this was a typical denial from short to long, but in I don't know if I'd say half the cases, sometimes the short term could be self-administered, meaning it's paid by the company, or they do it on their own, or they use a different company. But this case in particular was same Lincoln for short term and the same Lincoln for long term?
Yeah, Lincoln did the short term. They were administering it for the employer, but they, it was their people reviewing everything, and then Lincoln rolling over doing the long term review as well.
So we know that the transition from short to long term is one of the most common times for a long-term disability claim to get denied. The reason being is that usually there's a 90 or 180-day elimination period. More often than not, in these group disability policies, we see 180 days. So person basically has to have had their medical condition and been unable to work with that condition for at least 6 months. So that's one reason why it's common to see it happen at that point in time. The other reason is that now in the long term, you're going to a totally new person. It's never the same person who made the decision on the short term. It always goes to a new person. So what were the facts of your case that led Lincoln to deny your client?
Yeah, so she was young. That's always a red flag, as we know, a good benefit amount. And a lot of her conditions, although objective evidence, radiculopathies, back problems, she did have a diagnosis of fibromyalgia. She had a lot of medical conditions going on, objectively verified as being there, but they try to strip it down to the idea of the subjective complaints of the condition. Always acknowledging, yes, we understand you have these diagnoses, we don't agree. However, our doctors think that you'd be capable of doing your job. Your basic kind of standard rationale for a denial on a disability claim.
What was her job?
She was, and this is one of the most important parts of the appeal itself, she was a patient care coordinator for like hospice services, home health patient stuff. So her job wasn't just sitting at a desk, which is what they tried to do. They argued in the denial that we get the benefit of this national economy standard of your job, which all policies have. It's not how you do your job for a particular employer at a specific location, but how it's generally performed. However, it was our opinion they had the wrong job. They put her as a social worker. They stripped it down to a social worker, which is sedentary according to the Department of Labor. So they had three...
And a totally different job.
Totally different.
Totally different, even educational requirements.
Completely different. They try to say medical social worker, but then all of their coding was just for a regular social worker. And they had 3 doctors review the case, which admittedly is a lot. Normally you'll see just nurses review it, maybe one doctor, seconding an opinion of a nurse, but they did have 3 doctors, render opinions, and those doctors did find restrictions. It was just that all those restrictions would allow her to do sedentary work. So in the appeal, one of the biggest things was really hashing out what the occupational duties were. We used their doctors' own opinions as restrictions and limitations to support our position, in addition to additional testing that we did. But the vocational side of it was one of the biggest components of it, for sure.
So what was the definition of disability?
The inability to perform the material, duties of your regular occupation.
And who did they rely upon to deny benefits?
They had, like I said, 3 doctors. There was an internal medicine, occupational medicine, and then they did do a psychological review just because, one of the conditions is, mental health, which we see commonly. There's, secondary on it.
Right.
And it was the occupational medicine and the internal medicine's opinions which really were, formed the basis for the denial.
So what was your strategy on appeal to get the benefits overturned?
Well, one of the biggest things is if they're saying she has the capable for full-time sedentary work, or in our opinion, her job, as we argued, was light duty, physical. If they want to say it's a subjective, we have objective evidence. We have MRIs, we have EMG testing that shows that these problems are here. So in this situation, we did use a functional capacity evaluation. one of the issues that was of concern for me is that she had contacted us, several months after the claim was denied. So getting the FCE done was almost close to 4 months from the date of the initial denial. And a lot of times insurance companies will also argue, well, yes, this is how she was as of this date, but as of that transition date to long-term disability, it wasn't. So there's always kind of some concern there. So the functional capacity evaluation came back that she had no safe capacity for work and the idea of being in a workplace. And we were able to work with multiple of her doctors and physical therapists that she had treated with to second those opinions and argue that it's been, that this testing was representative where she would have been even during the short-term disability period. So we built up the medical evidence to give them that nexus between what the medical records were saying and actual physical ability. In conjunction with the doctors.
Did you build up medical support such that she was unable to do her light duty job as a patient care coordinator, or did you say that she was unable to do any gainful occupation even if it was sedentary?
Both. So in doing it, the information came back she wouldn't have full-time sedentary capacity. So we argued, you're wrong, her job's light duty, she can't do light duty, and even if it was sedentary, the evidence does support that she doesn't have sedentary work capability. I always like to do my appeals, even if we're in an own occupation. Here we are, we know we're going to get 24 months before they do an ENEOC. I like to set the stage very early that this person isn't going to be able to make a transition into some other type of work, because realistically they probably would argue that their sedentary occupations would be available to her based upon her training and education and everything. So set the stage relatively early on that.
So you were anticipating that, hey, I want to, look, by the time you do this appeal, you're already going to be 9, 10, or even a year into the own occupation definition of disability, knowing there's only 2 years of that, and then the definition is going to change. And in speaking with your client and the medical providers, you were able to show that she can't do any job, which you were really setting her up for the future, saying that I don't just want to win the battle, I want to win the war here. Also, I want to go, if you're telling me that you can't do any work, then we got to prepare for that now. Now, doesn't mean that they may not cut her off or at least try to at the 24-month mark, but at least you've laid the foundation, because if you had gone the other route and said, oh, she can only do light duty, then you might have been shooting yourself in the foot for the next stage, and they might have just said, okay, we'll pay the own occupation, but we're not going to pay the any occupation. Also, the information you got, because it was so early on, was also very helpful for her Social Security disability claim.
Yeah, which is pending right now and looking good. And I think another big thing in this case, which is very important, especially in the short-term to long-term transition, I think people get lulled in this false sense of security and that the insurance company is getting their medical records, because they've done it. They've set a precedent of getting records. But we've all seen letters where it says, hey, you have to provide this to us. In the appeal, there was some, I believe, close to 5, 6 providers that Lincoln didn't have any records from. Like, they didn't bother getting records.
Did they know about that?
She said she had told them, but they, she had said that they told her, oh, well, we don't need those records. We just need them from X, Y, and Z doctors. So, you may have, outside, I told her, like, listen, let's get everything you have. The only thing we realistically don't need is, like, your dentist or your OBGYN. It's not relative to it, but any other doctor you may have seen because of a complaint you have that can be related to the disability, we need to get. It's a situation where you want to dump them with so much information. Really stockpile it early.
So it sounds like Lincoln really took advantage of her early on, or whoever the person was when she called in her claim was like, no, we don't need this. Or if she sent in information, they chose to ignore it. And that's because they're, it depends on the experience and skills and qualifications of the person initially who got the claim to even determine. They found one doctor or whatever where they had weak medical evidence. They jumped on that and said, see no evil, hear no evil. I'm not looking for anything else. We're just going to deny you. And then luckily she was able to have you come in, really put the full picture together, work with her doctors, get the vocational assessment done, and present everything, and now get her back on track. And she's young, so this is potentially going to be a claim that you're going to be monitoring for many years to come to keep her on claim in the event that she's not able to return to work. So congratulations on a great victory. It's always a little bit more challenging with the younger people.
Very much so.
And why is that, though?
I think the insurance companies, and like I said, they did 3 medical reviews where we normally don't see that. I think they're setting it up with the idea of where this may go when it goes to court, if it ends up in litigation. And I always like to tell anyone I speak to, you have to look at it from that lens and then work backwards on it. So they build up the claim to try to deny much stronger on younger claimants, because if they do end up in court, they're working against this idea of a reasonableness standard in the denial. And they're also looking at the financial liability. You know, one of the things like we discussed, in short term they administer, it's not their money. It goes to long term, it's their money. So now they're thinking, how much are we going to be paying this person for the next, you know, hopefully it's not the case for her, because I know she is motivated. She's young. She wants to get back to work. But realistically, we're talking almost potentially 30 years of benefits under this policy. So younger insureds and claimants, they're always going to, in my opinion, look to try to find ways to poke holes and fight it more often than not because they want to. And or the denial comes because they want to pressure the person, maybe just go back to work. They're like, all right, well, the money's not coming. I have to go back to work.
And I know we're saying younger, it's subjective. I mean, she was in her 30s, but I find the younger to be any of the claimants under 50 because, you know, these
You're
policies...
still looking at like 15 plus years now.
So yeah. I think if someone was like, what do they mean younger? So, but she was really younger. She was in her 30s.
Yeah.
But I think anyone under 50 is going to have a higher level scrutiny. Although, you know, we just looked at a claim yesterday where the person was 62 years old and they, you know...
Before coming in here, I took a call and she was 63 and she was just getting denied. You know, she's been on claim 5 years.
It's ridiculous. Well, if you're someone out there who has a Lincoln Financial claim, feel free to reach out to Stephen or myself. No matter where you live in the country, we're available to assist you at any stage of your claim. We'll always provide you with an immediate free phone consultation, and we look forward to speaking with you.